I'm going to talk about the form of wording used during interview under caution. The legislation for this is the Criminal Justice and Public Order Act 1994, and that particular piece of legislation changed the wording. The wording for an interview under caution is this: you do not have to say anything, but it may harm your defence if you do not mention, when questioned, something that you later rely on in court. Anything you do say may be given in evidence. Now, this particular form of wording is used by the civilian police, the Royal Military Police, and civilian investigators such as the Department for Work and Pensions. And it's the form of wording used at the start of an interview under caution of an individual who is suspected of committing some type of offence. The form of wording can be split down into three parts. The first part is this: you do not have to say anything. It's fairly straightforward. It means that the individual cannot be forced, cannot be compelled to give an account to the investigator. And the third part equally is relatively straightforward. Anything you do say may be given in evidence. And that means that a recording may be made of the interview, and that recording may subsequently be given at any court hearing or at any trial as evidence for the prosecution. The middle part of the interview under caution is a bit more complicated, and it concerns the adverse inference. So this part of the caution is quite difficult to understand. It may harm your defence if you do not mention, when questioned, something that you later rely on in court. What that means is this: if the matter proceeds to court, if it proceeds then to trial, and at trial the defendant gives an account to the court that they did not give at the time of the investigation, at the time of the interview under caution, it might be that the court might draw an adverse inference against them. The court might ask itself why the defendant is giving an account at trial that they did not give to the investigator during the interview under caution. So that concerns the adverse inference. So a individual who is being interviewed, whether that's by civilian police, by the Ministry of Defence Police, the Royal Military Police, the Department for Work and Pensions, or whomever, they will generally have three options. The first option would be to make no comment. The second option would be to give an account. And the third option would be to give a prepared statement. And there are advantages and disadvantages to each. To consider first, making no comment. Well, as I've just explained with the caution, if the individual gives no comment, if the matter then goes to trial, and at trial the defendant then gives an explanation, having given no comment in the interview, it might be that the court might choose to draw an adverse inference against them. But there are occasions where it might be appropriate to make no comment in the interview under caution. For example, if there is a risk that an individual might incriminate themselves if they were to answer questions, it might be more appropriate, depending upon the circumstances, it might be appropriate for them to make no comment in order to avoid self-incrimination and then to take the risk of an adverse inference at trial if it went that far. Likewise, answering questions, that tends to be the opposite of making no comment regarding the risk. An individual who answers questions runs the risk that they might incriminate themselves, but the advantage of answering questions might be that they avoid the adverse inference if the matter goes to trial. The third option might be to give a prepared statement. That would normally mean answering no questions to giving no answer to the interviewer's questions, making no comment, and then afterwards giving a written prepared statement. So to give some examples of when it might and might not be appropriate, for a individual being investigated by the Department for Work and Pensions, for example, for benefit fraud, for example, for failing to declare that they are living with somebody, generally those matters tend to have little evidence other than what's said in interview under caution. And therefore, it might be appropriate in such a case for an individual to consider making no comment. But by comparison, if an individual has an explanation, has an alibi, or has a defence, or, for example, wants to raise an issue of self-defence or an issue of consent, it might be appropriate for them to answer questions in order to avoid an adverse inference if the matter goes to trial, but they would run the risk then of self-incrimination. The third option would be to gather information as to what the allegation actually is, listen to what the investigators put to the individual, make no comment, and then give a prepared statement, submit a prepared statement. That way, it would depend on the circumstances, but that way avoiding the risk of self-incrimination and also potentially avoiding the risk of an adverse inference.